What's up, YouTube? Tube? I'm back with another video. I'm kicked out of my room right now because we have a bunch of people over who are playing Minecraft, and then I remembered I have to make this video tonight. So now I'm out in the hallway. So let's get into it. We have chapters 5, 6, 7, and 8, but 8 doesn't really count because it's just a review of everything. So let's get into it. First, chapter 5. That just goes over how to read, how lawyers read. We have instrumental reading, which is basically reading with a closed mind, and you're just skimming a bunch of material, which you can get through it fast, but you're just skimming it and seeing what pops out at you that you could use in your argument, right? Now, the cons of that is you could misunderstand or misinterpret what you're reading, which then leads to bad arguments. To counter that, we have active reading, which is reading with an open mind. You're reading with great detail. You're reading to understand. You are reading forever because you're not skimming a single thing. It just takes a long time. Now, and they also like active reading. You keep first impressions provisional. Like you don't immediately like hop on something. Like no, you go and you research it. You make sure like you fully understand what you're reading. Now, as a lawyer, you want to combine the two. Instrumental reading with active reading, which is basically first you instrumental read, you're skimming over here, and you flag stuff, you highlight stuff that could be useful to your argument. Then you go back in with the active reading, and you're like, I wonder where this actually came from. I want to know the whole gist around this and all this and that. And then also with reading, you should also not just look for stuff that would build your argument, but stuff that could potentially counter your argument. Because you don't want to look like a buffoon on the stand when your opposing counsel says something that you weren't prepared for. You don't have an argument for it. You're just like, because then you look dumb. Then we move on to chapter 6, make them accept your premises. Now, chapter 6 mainly focuses on, I believe, the major premise. I guess we'll see. Okay, so for your judge, you want to create an impression that your way is the only way. There's no other way your judge can rule. Even if they want to, they can't because they're bound by law. That's the impression you gotta create. Now, how do you create that impression? Establishing certainty of authority. So we got a bunch of sources of authority. We have binding authority and non-binding authority. So for binding authority, we have three main possibilities. We got a supervising court, no higher court, legislature or statute, and the Constitution. You can never go wrong with the Constitution, maybe. And yeah, when it comes to cases in the statutes, though, they have to be from the same jurisdiction. Now, for non-binding authority, we have statutes and cases, but they're from a different jurisdiction. Secondary authorities, and you can even use big guns like Hamilton, Madison, or Jefferson. Always speak those old men. Now, direct grounding. Oh, this is basically just talking about citing. For like statutes, you can always do plain meaning rule. You can never go wrong with that, which is basically just stating bar for bar, word for word what the statute is. Or you could cite case authority, which is kind of basically like if a high-ranking judge has interpreted the law in a certain way, you could cite what they're saying. Usually paraphrasing is sufficient, and then you want multiple sources. Argument with multiple sources is a good argument. And then you can always indirectly ground your major premise. I don't think I really have to go over that. And then, yeah, establishing certainty and context. That goes over steps, tests, and factors to formulate your major premise. Using tests is basically, you can find that a lot in case law, where it's just like here's the test that you have to prove that something is this. Like, I don't know an example I can give right now, but you know what I mean. Like, you can put that in your major premise. And then we have step analysis. That's just steps to show court how to come to us like a correct result type thing. I'm sorry, I keep saying type thing. And then factor analysis, which is basically just trying to show as many factors as possible. And then you have balancing tests and stuff like that, but like I'm running out of time and we gotta get through chapter 7, which is all about minor premise. So you can create a minor premise by grounding in evidence and elaborating the meaning of key legal terms. So first we have grounding in factual evidence. types of evidence you can use. You can use affidavits, exhibits, stipulated facts, all that. And you want to cite it directly. If you don't cite, it's going to be bad. It's going to be bad. And you want multiple citations as well. You want a lot of citations. But not too much. A good medium, a happy medium. And then you also want to like appeal to common sense, because the court interprets a law that requires factual assumptions about the world. So yeah, if you make it look simple, if you make it look like a fact, the court's gonna eat that up every time. And then we talk about establishing brute facts, which is like about the physical world, what someone said, did, or perceived. Those are always great to use because it's kind of hard to dispute. And then elaborate key legal terms, basically. You identify all the legal terms, and you make it clear to the judge, here's how you know it when you see it, type thing. You want to show the judge, you want to basically explain to the judge, this is blah, 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 the legal term, and then relate it to your case. Now, you can see how it affects here, or how it does not play out here. So, yeah. And then you always want to avoid conclusory. I'm not even going to attempt. You know what I mean. Arguments, which they fail to spell out their reasoning or make assertions about the laws without backing. You're never going to win that argument. And then that's pretty much it for Chapter 7. You want to make sure all of your minor premises are adequately grounded by doing the why test. Okay, well, this is this. Why? Well, it came from here. Why did it come from there? Because it came from this. Like, you just want to go back, make sure all your stuff checks out. And then Chapter 8 is just a summary of the whole thing, and I'm way over time. So thank you for coming to my TED Talk.